As promised, I want to talk to you a little bit about the appeal process for Medicaid home care in New York. It's a little bit complicated. Well, okay, it's a lot complicated. And I'm getting a lot of calls from people who have had their hours cut and people who received insufficient hours to begin with for their mom or dad, and they need better hours in order for mom or dad to continue living in the home and for the adult child to be able to continue working or caring for their own children or whatever it is they need to do in their lives. So I want to talk a little bit about what the process looks like, because there are certain basic things that we have to address before we can actually get the hours increased or stop a cut from going into place. Let's first start with your mom has insufficient hours. Let's say she has 5 hours and she really needs 24 hours. And that's really not a ridiculous scenario. We hear that a lot. So what people often do is they'll ask, hey, managed long-term care plan, can I have another 5 hours so I get 10 hours a day? Or can I have 8, can I have 12 hours a day? And the plan will come out and they'll do an assessment and say, they'll go back and they will get back to the person and say, you asked us for 10 hours or 12 hours or whatever the number is, and we're not giving it to you because of A, B, C, D, and E. So what you might do next is what you actually have to do next if you're going to do an appeal is you have to first appeal to the plan itself. So if you have, let's say, VNS, you're going to ask VNS to reconsider. That's called a plan appeal. Okay, let's say you do that and they get back to you and they say, yeah, we reconsidered, we agree with ourselves, we're only giving you 5 hours. Or we reconsidered your request for 10 hours and we've decided we're going to give you 1 more hour a day so you can have 6 hours. That's usually when the person will call my office and say, hey, the plan denied me, can we do an appeal? And the analysis kind of goes like this at that point. If I do an appeal, we have a couple of avenues that we can go through to do the appeal. We can do an external appeal, and that's done through the Department of Financial Services, just like as if you were appealing or your doctor's office was appealing a denial of a procedure or something like that. That's a really good avenue to go through to appeal a denial of a Medicaid increase or increase of hours for home care. We could also do a fair hearing. Now, if we want to get 2 bites at the apple, we're going to start with an external appeal, because if we get denied the external appeal at the external appeal level, then we have the option to get another bite at the apple by going to a fair hearing. But here's the thing. This is the point at which I'm often telling a client, hey, let's start over again. The problem with taking that denial to appeal is I can't get you any more hours than you asked for. So let's say you asked for, hey, instead of 5 hours, can I get 8 hours? And then they deny you, and then you appeal them, and they hold steady on their denial. And I take it to an external appeal, I can't get you more than the 8 hours that you asked for. Now, often what I hear from clients is, well, listen, I only asked for 8 hours because I wanted to have a good chance of getting approved. I figured if I asked for 12, they'd say no. Figured if I asked for 24, they'd say heck no. Which isn't a good strategy, actually, because what I'm usually going to have the client do, and let's assume for the sake of this conversation that the mom or dad really does need 24 hours care. They really, we've got bedbound people that only have 5 hours of care authorized by the managed long-term care, and they need turning and repositioning throughout the night. Maybe they already have a bed sore, and if they don't have a bed sore, they do not want to get a bed sore, or they're incontinent and they need diaper changes throughout the night or something like that. It's not uncommon to see people like that getting only 5 or 6 hours from the managed long-term care plan. So in that type of a situation, what I'm going to recommend to the client, and I want to kind of put this concept out there because it's a shame to have to wait and go through what you've already gone through, asking for more hours, getting denied, doing a plan appeal, only to come to me and tell you, okay, let's start all over again and do it this way. So what I would have you do is I would have you make a request for 24-hour split shift care, assuming that the needs justify it. I mean, we're always making that assumption. The needs have to justify it, of course. But ask for 24 hours care, 24-hour split shift care, and ask for it in writing. That way the plan has to come out, reassess mom or dad, and then they're going to go back and they're going to more than likely deny it. So once they deny it, then you're going to ask for a plan appeal. I usually let the client go ahead and do that because 99 times out of 100, the plan denies it anyway. So I don't like to waste their money paying me to do the plan appeal. We can, but it's at this point, it's a matter of expedience and cost effectiveness. So let's say they'll deny your 24-hour split shift request. When they deny it, you call them up and you do a plan appeal. Then when they deny that, listen, they might not deny it, they might approve it. They usually deny it. When they deny it, then they're going to issue what is called a final adverse determination. We call it an FAD. So you're going to immediately ask for that FAD, and you're also going to ask them for a copy of the assessment. Now, the assessment is called a UAS. Uniform Assessment System, blah, blah, blah. So you're going to ask them for a copy of the assessment, and you are going to call them every day until they tell you they sent it to you, both the FAD and the UAS. Then that's when I can step in and prepare the case for an external appeal. And the reason I say then is because if you've asked for 24-hour split shift care, then I can get you that on appeal, assuming we win. If you ask for 8 hours, I can't get you the 24-hour split shift care, even though that may in fact be what your parent needs. So we're first going to make sure we make the right request to begin with. So I have plenty of cases where I say, go back, make a new request, ask them to come assess mom or dad for 24-hour split shift care. Then we'll go through the process, because that's when I'm going to be able to get you the best result. Now, typically I will begin with an external appeal. Now that can be done. There are doctor's letters that we have to get from your mom or dad's doctor to request an expedited external appeal. And that is an appeal that has to be decided within 72 hours. Now that's really a great thing. Now we have to get your parents' doctor records. We have to get the UAS and the FAD from the plan. We have to brief the case, because these appeals are done on paper. They're not done in a courtroom or in a hearing or anything like that. They're done strictly on paper. So what I have to do is I have to sit with the letters from the plan, the IAD, the initial adverse determination, the final adverse determination, the assessments that they've done, and I have to show the reviewer how typically how their own records justify what we're asking for. Now, once we get the appeal together and we file it with the Department of Financial Services, they are going to send it out to an independent reviewer. And then that's when the 72-hour time frame starts to tick. These appeals are reviewed by and decided by a doctor. They're not decided by an administrative law judge or any other legal type person. They are reviewed by a doctor. So the doctor's going to review the medical records, what the plan has said, the plan's assessments, our brief of the issues, and then they're going to come back within 72 hours and they're going to give us a decision. Very, very, very often, we don't have to go any farther than this. Now, if we do, however, I will have already preserved the right to a fair hearing when we first started the case. I will have requested a fair hearing, and I will have requested relief under a class action case. It's called Varshovsky. And to be really brief about it, that's a class action that was settled in New York that pertains only to people who have requested 24-hour split shift care. If we request a fair hearing and we have a doctor saying that that person cannot travel to a fair hearing, so must have a home hearing, what happens is they don't really schedule home hearings in any kind of a timely fashion. So if a home hearing hasn't been scheduled within 45 days, New York will direct that the 24-hour care be put in place pending the fair hearing. Now, like I say, we don't usually have to get to the fair hearing stage, but We want to preserve the right to have that care directed. If something doesn't happen within 45 days, let's say I'm having trouble getting what I need from the plan or what I need from your doctor, and this drags on a while. If 45 days goes by since I asked for the home hearing and nothing has happened yet, the state is going to direct that the 24-hour split shift care go into effect. Now, that happens sometimes. We will get that extra care pending the outcome of a hearing before we even get through our external appeal process. Not that often. The external appeals usually happen faster than 45 days, but sometimes you have trouble getting things from the various players. So we try to get both balls in the air at the same time. We want to hedge our bets. We want to get the fastest care that we possibly can for our client. So ordinarily, let's say the norm is we will get and you can never guarantee a result ever, but let's say the norm is we will get a good result from the external appeal from the independent reviewer. Then they won, and that's that. Okay, then the plan has to increase the care to the 24-hour split shifts, and we don't have to go forward with the fair hearing. And so the fair hearing we had it out there if we need it, but ideally we don't ever have to utilize it. So the reason I say all of this stuff is because everything we ask the plan to do, let's go back to the beginning and say, mom has 5 hours and you asked for 8, okay? By the time they say no, and by the time you do the plan appeal and they say no again, and you get the final adverse determination, that will typically be weeks. Okay. Then when you call me and I tell you, listen, based on what I hear about mom's needs, I tell you, listen, let's start over again. By the time we write a letter to the plan, ask them to come reassess for 24-hour split shifts, and they actually come out and do it, that could be a month before they get out there to do it. Then it could be another 2 weeks before they call you and say we're denying it. And then we will request a plan appeal, and then they will call you back and deny it. It'll be another 2 weeks before you get the final adverse determination. Then we're going to be on the phone with them every day until they send us the assessment. So we're losing a lot of time by having to go back and start over again. And every day that you don't have sufficient care in the home for your mother, that maybe you've had to take off work to be the caregiver because the plan won't give you the right amount of care, or you're trying to piece it together and there are some gaps and mom's home without care sometimes. I mean, every day that goes on is a bad day for you and a bad day for your mom. So I kind of want to get the idea out there that if you feel that your mom or dad needs round-the-clock care, let's ask for that to begin with. Don't be afraid of asking for too much. You're probably going to get a no anyway. So ask for what they really need. Don't try to play nice and hope that the plan will be nice to you if you don't ask for too much. Ask for what you need, and then let's take the fastest path possible to get that care in place so you have peace of mind and your parent has safety.